Good afternoon and welcome. Today is February 3rd, and this is the Ways and Means Committee hearings. We are starting a little after the original posted time, but we did let the public know at 1:30 because we had a briefing on a very important issue that ran over. So I appreciate everyone's indulgence. And we will begin with our first bill, House Bill 240, which is a Montgomery County delegation bill. And I believe Delegate Von Stewart is here to present it.
Yes, thank you very much, Madam Chair. It's great to see your illustrious committee this afternoon. For the record, I'm Delegate Von Stewart. This is House Bill 240. This is a local Montgomery County bill that passed our House delegation a couple weeks ago unanimously. It is extremely simple. It adds one at-large member to the Montgomery County Board of Education, which will be elected for the first time in 2024. The board in Montgomery County currently has 2 at-large members, 5 district members, and 1 student member for a total of 8. So this bill would make it 9 total members and 3 total at-large members. This is a companion bill to House Bill 380, which your committee will hear exactly 1 week from today. That bill is a familiar topic to all of us. It establishes in-district voting in the 5 districts that are on the Montgomery County School Board. So currently all 5 districts are elected at large, but that companion bill that you will hear next week would turn those elections into district races. There are basically 2 reasons why the delegation thinks we should add another school board member. First, with the possible implementation of in-district voting, the delegation thinks that an at-large member will create the right balance between members beholden to a local district and its parochial concerns and members beholden to the entire county at large. And second, and more simply, with the implementation of in-district voting, a divided board is more likely because obviously the members will be beholden for the first time to different groups of voters, and tie votes are also more likely. And so with apologies to any soccer fans on the committee, ties are bad. And so adding another member to the board will mean that there's an odd number, 9, and ties are therefore much less likely. And preventing ties is why the Maryland State Senate, the Maryland House of Delegates, the Maryland Board of Public Works all have odd numbers. And so this bill will also put the Montgomery County School Board in a position of having an odd number. And finally, I'll note that as you can see on your floor system, the Board of Education itself has actually voted to oppose this bill. Their reasoning is that they want the House delegation or the Montgomery County delegation overall to approve a long-awaited salary increase for board members before we add any new members to the board. And I'm sympathetic to this view, and I'm actually a big believer in increasing their salaries, which right now are very low, even though they do a lot of work. However, my hope and expectation is that the delegation will be pursuing a compensation bill next session. And so since this position won't be on the ballot until 2024, and the new member wouldn't be sworn in until January 2025, my hope and expectation is that the new salary scale would be in effect by the time this person is installed on the board. So with that, I urge a favorable report.
Thank you. I see Delegate Eversol has a question.
Thank you, Madam Chair. So they're holding out for more money before you add another person. What is the salary for a Montgomery County Board of Education member? What is their annual compensation?
That's a good question. I know that one of your committee colleagues would probably know down to the cent off the top of his head.
It's $20,000.
Yeah. Okay. I was going to guess about 25. So even I was going to overstate it. Now it's nominally a part-time position, but I think that they're grossly underpaid for what very much kind of like our own position can quickly become a full-time role. So I'm with them 100%. But I think that, we can go ahead and put this out, we can go ahead and pass this bill this year, give notice to the public that this new position is going to be on the ballot in 2 years, and then we can clean up the salary issue next year before this new member is put on the board.
Thank you.
Thank you.
Are there any further? Yes.
I'm sorry, I apologize. Delegate Stewart was correct. It's 25,000, not 20,000.
Oh.
Are there any further questions for Delegate Stewart? Seeing none, that concludes the testimony on House Bill 240. Thank you, Delegate Stewart. Next, another Montgomery County delegation bill, House Bill 243, that will be presented by our Majority Leader. Delegate Eversol, you can put your hand down.
Thank you, Madam Chair. House Bill 243 is another local Montgomery County bill. This actually has to do with compensation, but not for the adult members of the board, but rather our student member of the Board of Education. Way back around the turn of the millennium, so 20 years ago, Montgomery County enacted a scholarship for the student member of the Board of Education who works just as hard, does just as much work, and in some cases maybe even more than adult members of the Board of Education. That scholarship was set at $5,000. Of course, since that time, college costs have drastically increased. And when the Montgomery County delegation increased the adult member stipend in I think 2013, there was no attention paid then to the scholarship for the student member of the board. So this bill is intended to rectify that and actually to prevent that situation from ever occurring again. Because what it does is it ties the scholarship of the student member of the board to the highest cost tuition fees, room and board at a USM institution. And therefore the scholarship will permanently, under this bill, increase as college costs increase, and we won't have to revisit the issue on a regular basis. It received, I believe, unanimous support from the delegation, and I would urge a favorable report.
Thank you. Are there any questions? Okay, seeing none, that concludes the testimony on House Bill 243. Moving on to House Bill 261, sponsor only, Delegate Grammer. Good to see you.
Can you hear me okay?
Yes.
Madam Chair, good to see you. Mr. Vice Chair, for the record, Delegate Robin Grammer here to present House Bill 261. House Bill 261 protects local autonomy in the student sale of caffeinated beverages as part of a career exploration programs in Baltimore County Public High Schools. Current schools in Baltimore County are protected under current law. Parkville High School is asking for an amendment to the current language so that they can participate, as current language precludes their participation. This bill is pretty simple. It expands the language, and we hope to pass it this year cleanly, so we never have to do this bill again. It's passed multiple times. It passed the House last year. We are working on amendment to specify that this program should be limited to IEPs, and we should have that coming out of the delegation very soon. With that, I'd be happy to take questions, and I'd ask for a favorable.
Thank you, Delegate Grammer. Are there any questions for Delegate Grammer? Okay, seeing none, that concludes the testimony on House Bill 261. Moving on to House Bill 277, Delegate Patterson, and there are 4 other individuals to sign up. So after Delegate Patterson, those folks will have 2 minutes to testify. Whenever you're ready, Delegate.
Thank you, Madam Chair. Good afternoon, Chair Atterbury, Vice Chair Washington, and my colleagues of the Ways and Means Committee. For the record, I'm Delegate Edith Patterson, and I'm here to present House Bill 277. This enabling legislation is for the establishment of a Purple Star Schools program. What it does is, with the passage of this legislation, schools will be afforded the ability to provide strong services and support for military-connected families, and more importantly, for the military-connected students. Military families typically move between 2 and 4 times per year, between 2 and 4 years to a new school. So this legislation is really important to address some of the challenges not only the students but families face as well. The Purple Star Schools respond to educational, social, and emotional challenges military families face during their transition to a new school. What are some of the benefits? Well, the most important one is that there is a continuum of services from personnel who will keep track of the students and their progress. In essence, some of the services through this program include the designation as a military liaison to be included at the schools, the servicing of the point of contact between schools and military-connected students and their families, and also determining appropriate school services available for military-connected students. And lastly, the assistance in coordinating relevant school programs. And The main thing is that these schools will be identified before families even move into the area. There will be a web page recognized as a military star school, and it must include information regarding the relocation, the enrollment, the registration, and transfer of records at the school, academic planning, and counseling and other support services. The requirement to be recognized as a military school, they can do one of the many programs that are suggested, and they must include, one of them would be a resolution showing support for military connected students and their families, or they can host events recognizing the month of a military child or military family month, and of course, a partnership with local military installations. Currently, all schools in Maryland participate in a military interstate children's compact, but there is a difference because with the compact, they do not provide the services that I've just identified. How does this impact Maryland? There are 9 large military installations and districts that would benefit from our joining other states. There are approximately over 30 states that offer military star schools. And so we are requesting the ability to have Maryland join these other states and districts so that we will offer the services. You will hear from or view letters of support from advocates and supporters and parents who will offer invaluable testimony that will support you're granting a favorable report for the military installation of this, not the military, but the installation establishment of the Purple Star program. Thank you for your listening, and we ask for a favorable report.
Thank you, Delegate Patterson. And Delegate Patterson has a panel, and we will start with Christopher Arnold.
Good afternoon, Madam Chair, Mr. Vice Chair, committee members. My name is Christopher Arnold. I am the Northeast Region Liaison for the United States Department of Defense State Liaison Office, operating under the direction of the Undersecretary of Defense for Personnel and Readiness. We thank you for considering House Bill 277, which addresses the need to alleviate the challenges military-connected students face due to constant moves during their K-12 education years. My apologies insofar as my DoD colleagues and panelists were unable to remain for the late start. However, we understand you have received some detailed testimony from myself, as well as scholarly research, our installation commanders and school liaison officers from the military departments in support of the benefits of the policies in this bill. 28 states have already passed this approach, and with each move, military service members face numerous challenges as they bring their spouses and children to resettle into new communities and attend new schools every 2 to 3 years. Mobile military students face issues such as gaps and overlaps in curriculum, differing graduation requirements, course placement disruption, and many other hurdles when changing schools. Besides the academic issues, these students also face social and emotional challenges of relocation, such as leaving supportive social networks and activities to start new again. Creating a state-sponsored recognition program as a local opt-in allows Maryland's schools and districts to demonstrate their cultural competency and fluency as military-friendly schools, which have made a major commitment to students and families connected to our nation's uniformed services. Many neighborhood schools servicing the 9 major installations in Maryland would qualify for the designation on day 1, while other schools in the state will have something to aspire to. With the unprecedented challenges our educators, school administrators, and military children face in this day and age, the policy in this bill is more relevant and important than ever, and we thank Delegate Patterson for her sponsorship and leadership on this important initiative to provide a smooth educational transition for our military children. As always, as liaison to the Northeast, I am happy to answer whatever questions you may have.
Thank you. Next, we will have Tim Ferrell, please, for 2 minutes.
Good afternoon. Good afternoon, Madam Chair, and thank you, Delegate Patterson, and all the co-sponsors for the invitation to testify. Again, I'm Tim Ferrell. I'm a retired Air Force officer, parent of 2 military-connected students, and I'm the Chief Operating Officer of MSEC, the Military Child Education Coalition, and we're the national advocate for the Purple Star School Designation Program. We're very grateful for the sponsors in moving forward House Bill 277, and we urge its passage along with the passage of its companion bill in the Senate and ultimate passage across across the Maryland legislation to become Maryland law. As Chris articulated, with eventual passage of this legislation, Maryland will join the innovative and impactful precedent set by 28 other states that have already adopted and implemented this best practice compendium of meeting not only compliance, but more importantly, the spirit and intent of the Interstate Compact. Maryland and all of America's military-connected children experience academic and social emotional challenges as they relocate to new schools due to a parent's change in duty station, and also deal with both separation and reintegration challenges inherent to operational deployments. This has the potential to impact military readiness by degrading retention of service members and the economic viability of local communities and states that host military installations. So beyond the academic and social and emotional well-being impacts that have already been articulated, a Purple Star school program can also offer states the ability to protect local revenue. The Department of Defense typically includes the quality of K-12 schools near military facilities as part of its calculus in deciding future basing and personnel decisions. Communities with Purple Star schools can help retain those bases and missions and attract military families and bring economic benefit to those local communities. And Purple Star schools also foster diverse, inclusive, and supportive school environments through their initiatives and trainings, which serve all students regardless of military connection. MSEC has found that Purple Star school program has already gained traction and motivated hundreds of schools and scores of districts to improve services for military-connected students and families nationwide. This is especially notable given that the program has been in place for less than 3 years in most states, with a third of that time overlapping the COVID crisis. As
Mr.
such,
Ferrell, I'm going to have to ask you to wrap up your testimony, please.
Terrific. As such, MSEC just can't overstate how important and beneficial this legislation will be in ensuring Maryland's optimal compliance with its compact responsibilities, but ultimately in continuing and extending Maryland's leadership in supporting military families. I'm grateful for the opportunity to testify, and I'm available to answer any questions.
Thank you. Next, we will have Pete Lupiba for 2 minutes, please.
Thank you, Madam Chair. Good afternoon from snowy Columbus, Ohio. I developed this initiative with great leaders, K-12, pre-K-12 mill leaders across the state of Ohio in the summer and fall months of 2016 as an Operation Iraqi Freedom veteran and a military families advocate while staffed at the Ohio Department of Education. Sounds like Purple Star is sweeping the nation. The Military Child Education Coalition, National Military Families Association, and the US DoD itself embracing Purple Star schools as a quality of life priority for our service members and their families and their local schools. I've been in touch with K-12 mill leaders and state legislators from California to Maine and from Florida to Alaska. These 30 to 40 states are initiating their very own coalition and founding efforts through Zoom and the screen in front of us. I've been collaborating directly with local educators and nonprofits who want to hear about Ohio's story of Purple Star, our framework. Ohio's mission is exactly this, a grand grassroots, localized, bottom-up organic framework as first organized by state agencies, professional educator associations, nonprofits, and many more. The genius of Purple Star is that it is led by genuine boots on the ground, an all volunteer force by people with a passion which do not view this sacred shared work as other duties as assigned. It is a labor of love for that music teacher, school nurse, varsity coach, and so on. From your own spheres and communities, will find this coalition of the willing worthy of Maryland's champion of these kids and families. I think I can use the term kiddos as a dad of 5 myself, all under the ages of 10. Purple Star is for active duty, reserve duty, and National Guard service members, and of course, for their local educators. The Commonwealth of Virginia was the first to call on over to Columbus, Ohio, and request the Purple Star background and rubric and mission statement. Purple Star thrives in every part of your neighbor. To date, here in the Buckeye State, there are more than 400 Purple Star schools from 10 classes, fall and spring rounds in each academic year.
I'm going to have to ask you to wrap up your testimony.
We love it. From Lake Erie to the Ohio River, Maryland, get on board, join the Buckeye State and 28 states with ongoing legislation in Pennsylvania and on down the list. So thank you so much and go Big Ten.
Thank you. Next, we have Melissa Frasqueri. I hope I didn't do horribly on that. For 2 minutes, please.
Good afternoon, Madam Chairman and members of the committee. I'm a Harford County resident, military spouse, and proud mother of 2 military kids. For the last 10 years, my children have attended several schools throughout our nation, which includes DODEA and public schools. We've experienced 4 deployments and endless TDYs. Being away from our families makes us rely more on our community, which includes having the support of our children's schools. In 2017, my husband deployed while stationed in APG. At the time, our daughter was in 4th grade and our son was in kindergarten. Without a doubt, this was the hardest deployment we've ever experienced as a family. Our kids were old enough to feel the emptiness and pain of this process, which caused them to have a change in their behavior. Our daughter would cry almost every day whenever she thought of her dad in school. Our son would become angry. He was defiant at home because daddy left. I reached out to their teachers and principals. They accommodated Zoom meetings for special events and occasional lunch dates with their dad in order to provide a sense of normalcy. In our case, we got lucky because this school already had a nurturing environment and our daughter's teacher and assistant principal were also military children. Ideally, schools would have an understanding of our children's needs, have trained personnel to guide them when needed, and create spaces for military families to interact and bond. The support should be extended beyond the gates, especially when the military installation does not have a DODEA school, which means our children interact on a regular basis with classmates, friends, and faculty that might be unaware of their unique situation. Purple Star schools will provide educational and social and emotional support to our children when transitioning into their new community. It facilitates materials for personal development and professional development and guide each school to better understand our children. The Purple Star School designation would be the distinction Maryland schools need in order for our military families to feel reassured and to facilitate a sense of normalcy for our children. Thank you.
Thank you. And I see that concludes the testimony. I see we have a question. Delegate Guyton.
Thank you so much, Madam Chair. And I just want to thank our colleague, Delegate Patterson, for bringing this bill. I know I say it every chance I get to lately because I'm a newly proud Army mother. So I don't have a grandchild who's yet going from school to school, but I hopefully will if things go well for me and for my son. And so I just wanted to ask the delegate, do you feel that this bill is going to promote the priorities that we passed in the blueprint for community school and social and emotional health?
Thank you very much for that question. Yes, I do. I think it's really important to recognize that this is a specialized training for students that have unusual circumstances that occur. I think when you look at the collaboration between the military bases as well as the school system, and I'd like to also point out that we have support from the Maryland State Department of Education. So certainly this is needed service. When we think about the emotional support that these children or students will be offered, I think that it certainly touches on all that's needed and required.
Thank you so much for bringing this bill. It's a great one.
Delegate Lasanti.
Yes, thank you. And thank you to the sponsor, Delegate Patterson. I mean, I represent one of the largest military installations in the state and very well aware of the needs of our military students. I was just curious though, because, and we talked about this online, but maybe some of the panelists know this. When I was a youngster going to Harford County Public Schools, we had a very similar program that was sponsored by the federal government, and it was a real inclusion program to help not only the military students but also to help all of us to embrace our new friends and deal with anxiety issues and things like that as they left and things like that. And I was wondering, did this build out of that program? I don't know what the history is.
Copy. So Delegate Bonis, I'm happy to answer your question Delegate Lasanti. Sarah Bonis is the school liaison at APG in your neck of the woods. My apologies in getting ahead of myself in the answer, but a lot of the schools that are closest to the installations certainly may have similar programmatic activities in place. But in this day and age, folks are living further and further away from the installations themselves. And you may have instances of ROTC instructors recruiters, reserve and guard component families that don't reside anywhere near schools which have these sorts of program in place. So the schools that pursue the designation will have met these specified requirements to support the unique situations facing military students and their families, including the staff point of contact for military students, the dedicated website, the student-led transition program, and professional development for staff. And while I would defer to my other panelists as to the specifics on the ground, particularly Melissa at APG, I do know that there are a lot of schools throughout the Old Line State that would qualify for this designation on day one.
Great, thank you.
Are there any further questions?
Could I add to that answer since it started in Ohio?
Go ahead.
Yes, so in 2015-16, we looked around and figured bigger military states than Ohio had some kind of standard that said, okay, this is what a military family-friendly school looks like. So through that research, we didn't find anything, found it at the higher education, college, university level. So we came up with our own criteria, having professional educator associations come together, the State Council, MIC3, nonprofits like the USO, PTA, et cetera, and of course the veterans groups. And of course, every branch was represented and said, this is what a military family-friendly school should look like. And those are the tenets we deployed 5 years ago when we launched it at the National Museum of the Air Force in Dayton, Ohio. And that's kind of how we came about it. And to the delegates' comment on social emotional, we put it in our student supports section of the Ohio Department of Education. That's how Purple Star supported. And even in Texas, a big military state, TEA, they have it in their highly mobile and at risk student section of their agency or their Department of Ed. So it shows that the Department of Ed led and partnered with so many nonprofits and statewide associations can get this done in partnership with state capitals as well as the military, uniformed, and civilian leaders.
Thank you. Are there any other questions? Okay, seeing none, that concludes the testimony on House Bill 277. Moving along to House Bill 146, Vice Chair Moon. You got to change your thing to Vice Chair.
Thank you, Madam Chair. Ways and Means Friends, House Bill 146. I'll be honest, this was actually your Chair Atterbury's bill, and I inherited in her transition from the Judiciary Committee to this committee. It's a little bit appropriate, though, because the subject matter of the bill, in fact, lies at the intersection of education and the juvenile justice system and public safety questions. So in short, the bill is attempting to modernize the circumstances in which in Maryland, a school would get notified about offenses by students. Right now, this can happen with very little due process and at a mere arrest, not a conviction or finding of delinquency. And as a result, the students could be subjected to stigma, possible removal. And just to put your mind at the center of this, in the juvenile justice system, the goal is rehabilitation. It's very different than the adult system, and that's the dominant framework. What's good to get this kid back on track, and the records are confidential. And so the sort of current status quo of Maryland law sort of flies in the face of that framework. So this bill would change it from a mere arrest to a finding of delinquency or a conviction. And one of the big problems in current law is that there's a huge range of enumerated offenses that are reported mandatory at the moment. And I just flagged that it includes bringing plastic nunchucks to school, and that's actually specifically in Maryland law, on through to marijuana possession with intent. Again, this stuff could be happening off campus, and the kids not actually guilty of these things, but nevertheless, this is going to go over to the school. So I'm not going to argue that these are easy questions. We do have to draw lines as to when and under what circumstances to send this information. And I guess this bill would offer to start that process by narrowing what crimes we send and asking for the cases to be a little further along in the process. And this is actually where many other states are headed. With that, I will turn it over to my panel of experts who actually live and breathe this work.
Thank you, Vice Chair Moon. And next, so you do have a panel. We'll start with Renuka, and everybody on the panel has 2 minutes. I don't want to mispronounce your last name, so.
No problem. It's reggae, just like the music. So good afternoon. And I'm an attorney at the Public Justice Center. We provide legal representation to students who are pushed out of school, including for reportable offenses. And we've seen how the current reportable offense law is abused by school systems and can severely derail a student's education. We strongly support HB 146, which would reform the reportable offense process to shed light on and stop this hidden part of the school to prison pipeline. All students deserve the opportunity to learn regardless of their circumstances outside of school. Currently, Maryland law requires police to report to schools when a student is arrested in the community for any one of over 50 offenses. Schools across the state have then used this law to remove students with very little due process, even if the arrest had nothing to do with school. All of the well-known data and research that demonstrates the adverse impact of suspensions and expulsions also demonstrates the adverse impact of removals from school for reportable offenses because students are being disconnected from their education for alleged behavioral incidents. However, our reportable offense removals are governed by a much weaker process, legal standard, and accountability measures than suspensions and expulsions in Maryland, thanks to many of the changes that the General Assembly has made in the past several years. However, these reportable offenses often have nothing to do with school. And further, because they're not required to do so by state law, most Maryland school districts don't track data on these removals for reportable offenses. And so schools cannot be held accountable if they're removing students for unjustified reasons or in racially disproportionate ways or disproportionately by disability status. So to address these concerns, the bill directs school systems to follow existing school discipline procedures if they propose to remove students for reportable offenses, ensure that the student's counsel is included in the process of removal, and directs MSDE to collect data from local school systems on removals for reportable offenses, their demographics, and the reasons for removal. So for these reasons, the PJC strongly supports HB 146 to reform the reportable offense process. Thank you.
Thank you. Is Michael Gross here? Yep, I see you. Okay.
Good afternoon, Madam Chair and members of the committee. My name is Michal Gross, and I'm an assistant public defender in Southern Maryland, where I represent youth in juvenile and criminal court. I'm testifying today in support of HB 146, which proposes amendments to the reportable offenses for which a child can be removed from school. Section 7303 of the Education Article, the Reportable Offenses Law, is one of the most extreme collateral consequences for youth involved in the criminal justice system because it denies them their right to an education. Under the Reportable Offenses Law, students can be removed from school based on mere allegations entirely unrelated to school and for charges that may very well be dismissed. Over the past 2 years, we've seen the effects of remote schooling. It worked for some students, but was terrible for most. Reportable offense removals are worse than remote school, where everyone was in the same situation. These students are singled out and pulled from their educational environment, sometimes sent to an alternative school that doesn't offer the classes that they need, such as advanced placement or special education services or elective classes. And they're not allowed to participate in extracurricular activities like student government and athletics. But I've also seen this happen to children as young as 11 years old, too young for the alternative schools. I've seen an 11-year-old removed from school after being charged for a fight with a sibling at home. The student was placed on home tutoring, but the family couldn't transport them to the library, so this 11-year-old spent half of 6th grade doing worksheets at home alone. Reportable offenses are being used for situations where removal is not necessary for school safety. Children who are charged with very serious crimes are actually likely to be detained, and public safety, including school safety, is addressed by the judge when determining whether the child is detained or the conditions of release. And while Ms. Regge mentioned that there's no data collected, I can tell you that anecdotally, it's disparately applied to Black youth in the counties where I have practiced. HB 146 would fix what is one of the last vestiges of the school to prison pipeline, reportable offenses. It would significantly limit the offenses that can be reported and make sure that removal only happens when it is necessary for school safety. HB 146 also avoids unnecessary removals for cases that may very well be dismissed by changing the point of reporting from arrest to a finding of delinquency or conviction. For these reasons, we urge the committee to issue a favorable report.
Thank you. Next, LH, are you here? And folks, LH is a minor, so whenever you're ready.
Hello, how you doing?
Good.
Trying to pull up my letter. Okay. These last 2 academic years I have had many ups and downs for me. Coming out of quarantine and the most unexpected life experience of 2020 due to COVID-19, I was excited to return to in-person learning and bring things back to normal, especially with school sports. Even before virtual learning ended, I jumped at the opportunity to participate in the Southern Maryland 7-on-7 League my football coach shared with the team. After struggling academically for the first half of my freshman year in virtual learning, I went back in person and made the honor roll. Having the help with staff and access to my coaches and teammates motivated me to be a better student and leader. As an athlete, it is important for me to have a structured routine. My teammates and I look forward to the new 2021 season. We practice daily during the summer, and I also had the opportunity to become quarterback. Even though I had interest in the position in the past, I never formally played as QB, so taking on a new role was very important to me. When I first heard about the charges being brought against me, I was shocked. I knew that I didn't do anything, so I was looking forward to having a hearing and moving on. I started my seventh grade year and continued training for football. Then came the news that I was going to be removed from my home school and started classes at the alternative school the day before my first home football game. At first, I didn't even understand why. Then I learned it was from a situation I was accused of months ago that I had nothing to do with. I had to drop an elective course to not lose my main classes. It hurt me not only to miss my entire football season, basketball season, track season, but I wasn't even allowed to support my friends because I was told that I couldn't be on school grounds. I feel like I was cheated out of what was supposed to be an amazing year. I was excited to return to my home school, but can't help to remember the things that were already lost, and I pray they don't impact my future. I strongly believe the law should be changed so that no one else should have to go through things that I experienced. Thank you.
Thank you. Thank you for being here. And I know you're in the midst of your school day, so if you have to hop off, we understand. But thank you for sharing your story with us.
Thank you. I have a good one.
Next, Megan Berger.
Good afternoon. I'm an attorney at Disability Rights Maryland, the state's protection and advocacy agency for individuals with disabilities. I'm testifying today in strong support of HB 146. The current reportable offense law is outdated and out of line with current law. It doesn't include any of the critical due process protections for students contained in the 2014 discipline regulations. Even though the reportable offense law is supposed to be triggered by offenses that happen off school grounds and therefore have no direct nexus to school, schools have much more authority under the reportable offense law to remove students for longer periods of time than they do under the discipline regulations for in-school behavior. This doesn't make sense. For behavior that happens off school grounds with no direct connection to school, students should have more protections from being removed from school, not less. HB 146 fixes this by directing school systems to follow existing school discipline procedures for students. This is especially critical for students with disabilities because Maryland's current reportable offense law does not provide students with the legally required manifestation determination review and therefore violates Individuals with Disabilities Education Act and state special education law. Before a school system can remove a student from school for more than 10 days, the school has to hold a manifestation meeting to determine if the behavior was caused by or substantially related to the student's disability. If it was, then the removal is terminated and the student returns to their regular school. The reason behind this is to prevent students from being punished for disability-related behavior since the law requires accommodation. HB 146 fixes this by directing school systems to follow existing discipline procedures for special education students. Another problem with the current law that I see regularly in my cases is that some school systems are abusing the law and using it to banish students to alternative schools for school-based behavior and arrests that happen in school and should be governed by the discipline regulations. HB 146 fixes this problem by defining a reportable offense as an offense that occurs off school property and by directing school systems to follow existing school discipline procedures for students. This way, there is no incentive for school systems to attempt to evade the school discipline regulations by invoking the reportable offense law. For these reasons, Disability Rights Maryland strongly urges you to support HB 146. Thank you.
Thank you. Next, Ms. Christina Andrews.
Thank you, Madam Chair and members of the committee. I'm grateful to be able to present today on behalf of my former foster daughter and for the children and teens in my community. My name is Christina Andrews. I'm a resident of Cecil County, Maryland, a homeowner, a mother, and I was a teacher in the local school system. I knew very little about reportable offenses until last June when my 15-year-old foster daughter was suspended at school and then arrested for getting in a disagreement with a substitute teacher. As a result of the school-based arrest, the school system illegally relied on Maryland's reportable offense statute to deny my foster daughter her due process rights and immediately began the process of transferring her to an alternative school in the county. As a former special education teacher, I was aware of the rights of students with disabilities under IDEA and have participated in manifestation determination meetings and IEP meetings frequently. My foster daughter was not arrested because of an incident that happened outside of the school, but because of a disagreement with the substitute and school employee that happened in school. When I called the school to ask why my foster daughter was not afforded the protections under the school discipline and special education laws for students with disabilities, I was told it was because under the reportable offenses law, the school did not have to, and they were authorized to have a meeting without my foster daughter, her social worker, her lawyer, or anyone else representing her and making decisions about her future educational placement. I contacted Disabilities Rights Maryland, and they filed an appeal of the reportable offense decision with the school district and sent a demand letter to the school system requesting rescission of the reportable offense decision and immediate return of my foster daughter to a regular school placement. As a result of the appeal and demand letter, the school district withdrew its decision that the incident was a reportable offense and withdrew its decision to place my foster daughter in an alternative school. Disability Rights Maryland represented her in a manifestation determination review meeting, and the IEP team found that her behavior that had led to the incident at school was a manifestation of her disability, and therefore her suspension was terminated. The IEP team ordered updated special education.
Ms. Andrews,
testing. Yes.
Can you wrap up, please?
I sure can.
Thank you. Oh, you just went on mute by accident.
Sorry.
It's okay.
I support HB 146 to ensure that school systems can only use the reportable offense law for offenses that occur off school property, to ensure that school systems afford students due process and follow existing school discipline procedures for general education students and special education students if they propose to remove a student from school based on a reportable offense, and to ensure that the student's counsel is included in the process of removal from school. Thank you.
Thank you. Ms. Anita Lampl, please.
Hello, thank you, Chair Atterbury and members of the Ways and Means Committee. My name is Anita Lampl. I am a resident of District 16 and I'm submitting testimony on behalf of Jews United for Justice in support of HB 146. Jews United for Justice organizes 6,000 Jews and allies from all over Maryland in support of local social, racial, and economic justice campaigns. Jewish belief holds that all people are created in the divine image and that the destruction of life is akin to destroying the world. Yet suspensions and expulsions from school regularly destroy the lives of children. I'm a psychologist. I have a PhD from Stanford University, and in California, I headed a large child and adolescent mental health program. I worked closely with the Department of Juvenile Justice there and also assisted in writing legislation. I served as an expert witness in juvenile court, and I'm very familiar with children who have ended up in trouble. I will tell you that in California, behavior that students engage in off campus is not used as a means of expelling them or suspending them from campus unless they have been found guilty of that behavior, and then alternative educational programs kick into place. For example, I worked with a young woman who had killed her newborn child and she still was not denied her education, was able to complete high school and go on to community college. I could offer you more examples. When I moved to Maryland, I expected to find a system in place that represented this richly diverse and thriving state. However, I was disappointed to find that Maryland really has one of the worst records on juvenile justice in the United States. This current law, which allows for a young person who is only accused of a crime to be suspended or expelled from school for an alleged act that occurred.
Ms. Lampl,
yes.
Can you wrap up your testimony, please?
I can, yes.
Thank you.
I just want to add that suspensions and expulsions increase the dropout rate by 30% or more. This only throws our children out on the streets to end up in more trouble. So I urge the committee to return a favorable report. Thank you very much.
Thank you. That concludes the testimonies on the favorables. I see there's some questions. We'll start with Delegate Eversol.
Thank you, Madam Chair. I have to say that this is an area that I'm not very familiar with, so I don't know if everybody else is either, so I hope, but I have a couple of questions. I gather that reportable offenses are used to discipline students at school, even if they're not at school. Can someone start off by giving me just one example of an offense that would occur outside of school, where once the school knows about it, they would then take action against the student at the school? I'm not necessarily a suspension, but is there some sort of other discipline? Is there an example of that?
It could be, I'm just gonna throw out a couple, but then, Ms. Gross or Ms. Reggae, please jump in. But it could be anything from car theft to having indecent material to threats. It's really a laundry list of crimes in the criminal code, which, we're all here, we're all delegates. So the folks on judiciary at some point, whenever this was done, thought that these were the crimes at the time that should be in the code for reportable offenses that happen off-site.
But the kids could then be punished at school on some level, or perhaps expelled, but punished by being taken out of extracurricular activities based on that activity outside the school.
Or removed from school.
It sounds like that would be a more serious crime, but I'm more concerned about what you are concerned about, that something that didn't happen at the school influences their schooling. I'm a little concerned about one piece of the bill, and I'll go to the sponsor, I think, on this one, if I may. At the top of page 4, you've changed the language to say the state's attorney may notify the following individuals of the adjudication or conviction within 24 hours. Does that mean they may notify them within 24 hours, or they just may notify them? Like, they don't have to notify them if they don't.
I'll confess that's to be discretionary. I think the belief is that it's going to be the practice, but it at least opens the door that, one could find a scenario where maybe it would not be the appropriate thing to do.
Do you worry that the state's attorney might be selective in the people that he or she reports on, and that could reflect some bias?
Yeah, I guess that's probably the problem now with the current system, since it's automatic. I think in some way you're guaranteeing a more negative outcome. So I guess it's a real question what would happen if you made it discretionary. But again, I think if the concept is it's shrunk into crimes of violence, it could in fact be in crimes of violence and they've in fact been adjudicated delinquent or convicted. It may be the case that it is appropriate in the vast majority of these cases for the state's attorney to notify the school. Again, it just wouldn't guarantee it.
So the last thing I'll point out is if state's attorneys have discretion, and perhaps a state's attorney is some of their bias is creeping into the decision making, then your data collection that you talk about later on in section J might be skewed also, and that concerns me because it might actually reflect badly on certain populations. Maybe we can tidy that up a bit. I would love to do that.
Thank you. Delegate Buckle.
Thank you. I got to be honest, I have quite a few. I'll try to limit it as much as possible questions about this bill, just to understand it. And some of it is frankly a little surprising to me. And maybe Delegate Moon might be in the best position to answer this or someone else. My understanding in looking at the bill and reading the fiscal note is that you're eliminating the specific lists that would be if you take a look at the bill, it's basically from the bottom of the second page and the third page. You're eliminating a bunch of specific citations or references to crimes as reportable offenses and just creating a catch-all that says involved a crime of violence as defined in 14101 or involved in any of the offenses enumerated in 38A 03D4 of the courts article. I have no idea what those are. I crossed my office, look them up in the annotated code. Didn't have time to do that. I'm reading the fiscal note, and is this true? Is this accurate? That this bill would repeal provisions requiring the notification to the school system as a reportable offense for possession of dangerous weapons, for arson, for gang involvement charges, for stealing a motor vehicle charges, for first-degree burglary. Is that the intent of the bill? So kid gets charged.
I mean, I guess
17
as
with
I
those things
noted
and-
at the top of the hour, this is not an easy subject matter. And I guess, the crimes of violence has become sort of the catch-all we've used when we do need to make these sort of demarcations in law. The list you see enumerated there, I would say it's not entirely consistent in whether or not these, again, off-campus incidents have an impact on public safety within school walls that would warrant automatic notification. We can talk about whether you want to put some of them back in or not, but I think the starting framework was it was inappropriate to sweep them all in, again, at a mere arrest. And so the default in the bill is to start it back on crimes of violence being the public safety hazard. And again, if you want to modify that list, we can talk about that.
So let me ask, there's another element of the bill, according to the fiscal note, that says that it repeals the requirement that the local superintendent and principal consider prohibiting a student who's been arrested for a crime involving rape or a sexual offense from attending the same school or riding on the same school bus as the alleged victim of the reportable offense. You can't want that, right? Like, that's got to be a mistake. You can't say, hey, a 17-year-old boy has been charged with raping a 15-year-old girl at the same school, and we're not going to notify the superintendent or the principal so that victim, potential victim, is separated from having to see her rapist or her alleged rapist on a day-to-day basis in school.
Sorry, can you point me to a page?
Yeah, I'm in the fiscal note of my friend on page 2. The first full paragraph. I just read that. The bill repeals the requirement that a law
You are
enforcement
talking about
agency-
reportable offenses, correct?
Right. It says it also repeals the requirement that the local superintendent and the school principal consider prohibiting a student who is arrested for a reportable offense involving rape or a sexual offense from attending the same school or riding on the same school bus as the alleged victim of the reportable offense.
It's in the bill text, it's page 5, lines 15 through 17.
Thank
I don't know if it's helpful, Delegate Moon, if I can jump in just for a second.
Go ahead.
I think I haven't had a chance to review the fiscal note. I didn't actually receive a copy of it. But what I will say is that some of those charges that you are discussing are actually considered crimes of violence and would still be subject to the reportable offense.
So if a kid steals a car.
So what I was saying, though, I mean, it may be, I would hope, I'm not an expert in this, I practice law, but I don't do really criminal law. I would hope that rape is defined as a crime of violence under our statutes. If it's not,
Yes,
should do
period.
that.
And they struck it from the bill.
Right.
Eversol, I think you need to go on mute.
Sorry.
So, but what I'm saying is the bill, other than saying, okay, it's now a reportable offense, my reading of the stuff provided to us today says that under current law, the principal or the superintendent automatically gets notified about the alleged rape or sexual offense, and then has the ability to automatically separate those students so that the alleged victim is not in the same classrooms or riding the same bus with her alleged assailant. And that seems to be repealed under from what the fiscal note says. That particular element seems to be repealed from current law, and I don't think we would want that, would we?
So I don't want to jump in if Delegate Moon wanted to respond, but what I would say is that this bill wouldn't actually repeal that. What this bill would do would be to prevent non-violent offenses from being reported. So there's a few different things that the bill does. One is that it limits the types of offenses that can be reported. And number two, which is I think the two elements of it that are relevant to your question, is that it changes the time of reporting. So if, for instance, you have a situation like the one that you discussed, where a student is charged with rape, they are likely to be arrested and go before a judge for either detention hearing if they're in juvenile court or a bond review hearing if they're in adult court. As they go before the judge would make the decision whether or not to release that youth, dependent on whether or not there is a risk to public safety. I have seen judges, as a condition of release, say you cannot be riding the same school bus as this other student, or the alleged victim in this case. You cannot be attending the same school as the alleged victim in this case. That is still available. What this bill would do is it wouldn't eliminate rape or other violent, other crimes of violence from the reportable offenses law. Instead, it would change the time of reporting. So at the time of charging, a judge can still impose those conditions, but the school would not be imposing those conditions until after the case is resolved, if the student was in fact placed back at the school.
Okay, well, I appreciate your perspective on that, and maybe that's what the intent of the bill is. I'm just saying, from the materials given to us, there seems to be some dispute about that. I just one final line of questioning, and Delegate Moon or anybody else, I was, like Delegate Eversol said, this isn't something that I think our committee has heard directly before, so I was a little taken aback. Are we suggesting that the disciplinary process somehow has to be different if the crime is committed on school grounds? And I'll tell you the background. About 3 months ago, in a high school in my city of Cumberland, Maryland, two boys had words with each other throughout the day. One boy was a very successful football player. He was looking to get a Division I scholarship, played at Fort Hill High School, state champion. And they had words with each other in the preceding days. I think it was frankly about a relationship. And the other child, and I say that child, I don't know if he's 17 years old. He walked to the school grounds. He didn't go to school that day. He came as the school was letting out from, afternoon dismissal. And through social media and texting, he had said, I'm coming to school to, back in my day, we said, I'm coming to school, we're going to beat you up, or we're going to have a fight. He came onto the school grounds, basically in the parking lot or adjacent to the parking lot. And he stabbed Saquon Barkley. He stabbed him several times, killed him, 17 years old, killed him in the parking lot. Is there a difference between how we adjudicate or how we would report that or how we would deal with that individual if he had done it across the street, not on the school grounds? I was confused when someone said, well, we have a different system of adjudication if you commit a crime on school grounds versus if you commit it down the street. To me, it's still the same issue. So can somebody explain to me why that would be different?
I'll just quickly say, look, you raised some interesting scenarios, and we have had some of these bills in judiciary. In fact, we had a hearing yesterday on a bill from Delegate Parrott that was on a different aspect of reportable offenses and when there's notifications. And these things are not simple. So that's why I suggested again from the top of this hearing that this is an opening discussion about how to rebalance some of these questions. I think the main point, difference between something happening off campus and something happening on campus, well, there's already a nexus between the school and the incident if it happened on campus, and there's a process for that. Now, if it happened off campus, I think the heart of this bill is trying to answer the question of what should that nexus be? When and under what circumstances does that thing that happened off campus come into school? Should it be automatic? And I think here we start to see that the bill tries to say, well, I don't think it should be automatic. I think there should be some nexus to public safety. And again, no, I'm not trying to have rapists coming up against their victims. No, of course not. We're not trying to force confrontation. So again, that's the framework I'm trying to put out there. Let's work together to try and balance these concerns and come up with something that works. I think the other cases you heard about are legitimately concerning too, right? Someone sort of being swept out of school and removed on a mere allegation with little due process, and ultimately he didn't actually do anything, or a student who ought to be under an IEP and receiving services being sort of punished for their condition. These are problems too, and they're the result of having an automated process. Again, I don't know where the balance is. This is my first year taking a crack at this bill, so I'm happy to work with you on it. And education's not my primary subject matter, to be honest, but I'm very sympathetic to what the folks are trying to do here.
Thank you, Delegate.
Delegate Buckle, if I can just respond too. So I had this bill in 2020 in Judiciary, and Ways and Means was secondary. So you all sent, I think, 3 folks over. We were in person then and heard the bill. Interestingly, I don't know why it's only assigned to Ways and Means this year, and not Judiciary. So I think there's a couple things, and well, you don't know because you haven't been there, but Judiciary, we sit around for hours with all of these scenarios. This bill is not necessarily about the crime and the punishment for the crime. This bill is about reporting, and when that reporting should follow the student, should they have to leave the school, and who all should know about the incident. That's really what this bill is about. So this bill says that upon adjudication, not upon when the alleged incident happened off school grounds. Because if something happens on school grounds, it's already presumed that the school knows about it. And if charges need to be brought, or if the police need to be there, or we just spent 2.5 hours, if the SROs need to descend and take care of that situation, that's presumed to already have happened. This bill is about if something happens off school grounds, an alleged incident, the way the law is written now, any crime essentially could happen off school grounds, and the school would have to be notified. And so the question is that an issue of fairness? Is that an issue of fairness, particularly for your lower income students, for African-American students, for students of color, and for students of disabilities, where it's shown that those incidents follow those students around, those students don't get a fair opportunity for a quote unquote fresh start, which is what I know we all want. And so that's really what we're looking at here. We all know that we don't want a rapist, alleged rapist, sitting next to the victim. But I hope that clarified, Delegate.
No, I appreciate the concerns, and I'm sure we'll get an opportunity to have more discussions and work through if the bill continues to move through. I'm just concerned about where that line is. I'm not concerned about a 14-year-old who's charged with shoplifting getting kicked out of school. I am concerned about a 16, 17-year-old being charged with possession of a dangerous weapon and the school not having any notification of it, and then maybe that individual brings the dangerous weapon to the school or to a school-related activity. And I think that creates all kinds of not only moral issues or criminal safety issues, but all kinds of legal issues for the school and for the system. But I appreciate the opportunity to keep working with you and Delegate Moon about those conversations. Thank you.
Thank you. Delegate Lukey.
Thank you, Madam Chair. Delegate Moon, thanks for the bill. I think it's a challenging conversation, as you say, but I appreciate the intent behind it. I do want to return to that issue of sexual assault, which is on page 5 of the bill, lines 9 through 17. So I may be misremembering. I was Googling as you were talking here to try to remember. But as I recall, there was a specific incident that gained some prominence in the state of a young woman who was sexually assaulted. And the school, I don't recall whether they were notified or not, but essentially the rape survivor was required to continue attending school with the perpetrator. And I believe, I could be misremembering, but that was the genesis for this section of law. So under current law, it says that prior to adjudication, if the school is notified that the superintendent and principal shall consider prohibiting a student from attending the same school or riding on the same bus with a rape survivor. And once a conviction occurs, they're required to remove them from any close association with the rape survivor. As I read what happens in this bill, the school system isn't even notified that there's an accusation of sexual assault until the case has been adjudicated and the alleged perpetrator is adjudicated delinquent or convicted. So how would a school know, in order to prevent a rapist who, let's assume that this person actually committed the crime, from being in the same classroom with the student who survived?
Okay. Boone, are you going to talk? I was going to ask Ms. Groves to respond to that.
Yeah, so Delegate Lutke, what would happen is in that situation, if the first student was charged with rape, at that point, it would just be an allegation, right? And they would go through the court process that I discussed earlier. But if that child was actually adjudicated delinquent, basically found involved, found guilty, whether it was in juvenile court or in adult court, at that point, the school would be notified because that would still be subject to reportable offenses. A rape charge would be considered a crime of violence. And so then the school could act appropriately in making sure that these students are separated. But going back to what I said earlier, the consideration about whether these students were riding the same bus, whether or not, while these allegations were pending before they were actually proven, maintaining the safety and separation if necessary for safety, that's something that would be considered by a judge in determining whether or not that individual is released, pending trial, pending adjudication in juvenile court. And so there are considerations at every single step to maintain a safe environment. And the purpose of this bill is not to forget about public safety. It's understanding that public safety is a concern, but we also have to be worried about those students who are being removed on mere allegations, not for rape, but for things like getting in a fight with their sibling at home, a sibling who doesn't even attend the same school as them. Those children are getting removed from school, and that case is very likely to be dismissed eventually. In fact, 50% of cases forwarded to the Department of Juvenile Services are resolved informally. So that student gets in a fight with their sibling at home, is removed from school for months. By the time the process is worked through, the student's been out of school for months, the case has been dismissed, and the student's just sent back to school. So it's not, I understand that the concern is obviously the worst case scenario. It's the 16 and 17-year-olds charged with rape. Those children right now would actually be charged as adults if this was a rape charge. They would go before a judge, and a judge would make a determination whether or not this child could be maintained safely in the community or whether or not there needed to be restrictions. And those restrictions can be detention. Those restrictions can be, I've had clients who were released on electronic monitoring at home with a specific condition that they could not attend school in person. Those are all things that are still available for the judge. What we are saying is that what this bill says is that their education should not be permanently harmed by their removal based on the mere allegations. We should wait until there's a finding of involvement or some sort of conviction or adjudication.
So I take your point. And I'm not a lawyer, and I don't know the legal process in detail. But it as a former school teacher, it worries me to not have information that's helpful to me in teaching. And so let me ask this question then. Isn't an arrest itself for the student who's arrested, isn't that a traumatic event for that student? But then we're asking schools to engage in trauma-informed education and to support students who have had a traumatic event occur to them, but we're not going to let the school know that this kid has been arrested and is going through trauma. So how is the school supposed to provide the support they're supposed to the child? And let me ask this in a slightly different way. If the issue is disproportionality in the response of the school to the report, then isn't the solution to deal with that disproportionality in the school end and not just to say the school never finds out?
So one thing that I would say to that is that if we want to be implementing that trauma-informed care, it would start with the relationships that the teachers have with the parent, that the teachers have with the student. We don't need to rely on the police to be notifying the teacher when an arrest happens in order to help the student who was arrested. If those relationships were in place in the first place, the parents would be talking to the teacher, the student would be talking to the teacher, and they would be able to put those things in place. So it's just, to me, it seems a little bit backwards to be relying on the police to be telling the school about an arrest so that the teachers can then help the student who was arrested.
And I would also add.
Oh, sorry, go ahead.
Oh, I can wait. Delegate Moon, if you want to go first.
No, go ahead.
Okay, I was just going to add to that even under current law, the teachers are not the ones who are notified.
Yeah.
What happens is the police notify the principal, who is under current law not actually allowed to share this information with anyone else in the school, and the principal makes a unilateral decision whether or not to remove the child from school. The teachers may very well disagree about that decision, and they're not even informed why the child's being removed. The child's just out of their class without any explanation.
I got you. So this child is arrested. They're dealing with all of that. It's a lot of stress to put on a child, right? And they're sent back to the school, and they're participating in the classroom, and maybe they act out or engage in behavior that they otherwise might not have. And the principal is assigning a suspension or other discipline without knowing that there's a potential proximate cause for the child's behavior that maybe is not best responded to by a suspension. So, I mean, that's my concern. I mean, leave aside, yes, I as a teacher, I would have loved it if every parent reported to me everything that they were happening in their kids' lives, but I had students that were abandoned. I had students that were abused, and there were parents who would not report anything about a student. So that's its own issue. But I guess, how does a school then do its job and appropriately respond if they don't have the information necessary to appropriately respond?
Well, I don't think there's going to be an answer to that question. It's sort of a thought question, and I'll just sort of reground it again to the theme I keep coming back to here, which is, we've had these bills coming in for years now. There were serious incidents. We heard about that one in Western Maryland with the school bus, quite repetitively in judiciary. But remember, this bill has multiple components. There's one question about whether this reporting should be automatic or discretionary, whether it should happen at arrest or conviction, whether there should be any notice to the attorneys and the social workers when these processes are triggered, whether the list should include many crimes or whether it should include only those most serious crimes, and whether anyone should be tracking any data as to any of these effects. I will just put it out there. I don't have the answer to a lot of the tough questions you're asking, or that Delegate Buckle asked, but that's at least 6 topics with a lot of possibility for progress on this. And again, no one solved this overnight thus far. So anything we can do to make this better, I think, would be appreciated.
Yeah, I agree. And I appreciate the intent behind the bill and appreciate the goal of it. One more comment, and this is not a question, and this is general for the subcommittee and the committee to consider. The designation of what happens on school grounds or off school grounds has actually been an issue because school systems are now required to report to the Center for School Safety incidents that happen on school grounds. So we've seen instances in school systems around the state of misclassification of issues as off school grounds simply because people don't want to fill out a report. So that's an issue raised by this on and off school grounds thing as well. Thank you, Madam Chair.
Delegate Griffith.
Thank you, Madam Chair. And Delegate Moon, great to see you again. I've missed you very much. And this question is for either you or Ms. Gross. So in judiciary, we took a lot of these issues, and the concerns are always, the judiciary having to interpret the will of the General Assembly, right? That's why it's always important. We're extremely definitive in exactly what our will is. One of my concerns here, and it happens a lot in the bills in judiciary especially, was unintended consequences, right, would come up. So if there's a judge, for example, who has a kid in a school who's aware of this and sensitive to this, is it conceivable that judges may now have to be harsher on individuals in these circumstances to raise them to the level of reporting to keep them out of school, thereby potentially creating more children that are entering the school to prison pipeline?
I mean, it sounds like the question you're asking is whether this puts the onus on judges to sort of get conditions correct for some of these kids. I mean, it's a fair question. Part of that, I think, can be remedied by if we can at least get some consensus on which crimes we're even talking about, and at what stage of the process and who's notified. Again, I don't think everyone's going to come to the same conclusions on which crimes should be included on something like this. But I think we could certainly try to get a little bit closer in consensus there. And it makes that distinction, hopefully, a little bit less concerning for those who are, don't agree on that list of crimes, right? That if we at least narrow it to the most serious of crimes, then how we go on some of these other decision points becomes less concerning, at least for me. But again, I think this is obviously going to take a bit of work session work to try and achieve that consensus.
Thank you.
Delegate Griffith, what I would add is that similarly to the discretion that a judge has at a bond review or at a detention hearing, a judge has that same discretion when it comes to a disposition hearing, when deciding whether a child should be sent to a juvenile placement, whether they should be released home on probation. And they can, much like they could do this, as a condition of release, they can make a condition of probation, stay away from the complaining witness in this case. And what that will eventually do is, as part of, in order for the child to comply with their probation order, they need to approach the school and find a way that they have separate classes, that they're not interacting with each other. And sometimes that will lead the child's parent to request a transfer to another school.
Sure, and that's a possible scenario, but isn't another possible scenario that a judge could, increase the penalty against a student to make sure they hit that threshold?
I understand what the concerns are, and I appreciate that that is a concern. I think it would come down to whether or not the judge was thinking about that through the adjudication process, through a bench trial, or if that is the concern.
I'm just asking if it's possible.
It's always possible. I would hope that we have more faith in our judicial system, that we wouldn't expect a judge, when they didn't think a charge was proven beyond a reasonable doubt, that they would not find a child involved just so that they could have them removed from school. But I understand the concern.
Judges are people too with kids in school, so thank you.
Are there any further questions? Okay, thank you. We have 4 individuals signed up opposed. We'll start with Ms. Afi Nayar for 2 minutes, please.
Good afternoon. My name is Dr. Afi Mirshanayer. I am the president of the Maryland Association of Secondary School Administrators. We represent all middle and high school principals and assistant principals, and we strongly oppose House Bill 146. As school leaders, we rely on information to help keep our schools and our school communities safe. In reading the language in the proposed House bill, we find it entirely disconnected from the day-to-day reality of how school administrators work with police in cases where there are allegations of serious crimes committed by students in our school communities. Much of the language written into HR 146 doesn't match with our experiences and in fact offers an inaccurate portrait of common school practices. We strongly oppose the elimination of mandatory notification to schools regarding reportable offenses. Reportable offenses include crimes of violence, sexual offenses, assaults, other related acts of physical violence, drug-related charges, and weapons. There is good that comes from school leaders having information regarding allegations of serious crimes in our communities at the time of arrest. The information we are provided is used to protect both victims and alleged perpetrators to ensure they all have access to their educations. School is not disconnected from our communities. In fact, we are the epicenter of our communities. What happens in the community impacts safety and security inside our building. In addition to removing critical information from schools, this bill imposes new and unnecessary requirements on school systems. In these days of 24/7 information being shared on social media by students, schools are already at a disadvantage. The potential impact of this bill could create an unnatural division between schools and our communities. If the bill is approved, it has the potential of impacting safety in schools at a time when we see our students are grappling with mental and social emotional challenges that have led to increased inappropriate behaviors by students. We ask that you trust school leaders in Maryland and that we ask you to oppose in the best interest of our students and our communities and act in opposition to HR 146. Prompt notification to schools is critical and should be mandatory for all reportable offenses in order to ensure timely action when it is needed in order to promote a positive school climate with a focus on safety and security of our students and our school communities. Thank you.
Thank you. Next, Mr. Willems. Is Mr. Willems here? Okay, I will circle back to him. Next, Miss Tammy Fraley.
Hello, my name's Tammy Fraley. I live in Allegheny County. I have 2 children that attend public schools and 2 children that graduated from public schools. I'm speaking today as a parent with children in the school system. In the pandemic has greatly influenced kids in school. We've noticed an increase in violence. My child, who goes to a high school, has seen fights, has seen things happen outside of school that get brought back into school. My husband was a school resource officer in Maryland for 14 years, but now works in West Virginia. But during his time in Maryland, I heard of stories of examples where a reportable offense, it was key for that administration to know the next morning that something had happened the night before. It could have been an assault charge, but if they did not know and a child came to school the next day to finish the job, my husband saw that many times. As a parent, I feel that the safety and security of schools depends on that full disclosure to the school administration on acts of students that are considered reportable offenses. As has been said previously, a reportable offense is not some petty violation like a traffic offense or a moving violation. These are crimes that include assault, malicious destruction of property, arson, guns, rape. To even be charged with them means there was some probable cause to be charged. School systems have policies in place to ensure proper restorative practices are followed. My husband had a case when the potential assault charge notification enabled the school to simply separate the 2 students from each other the next day. What would have happened if that wasn't told? This bill essentially eliminates the reportable offense statute and process, thereby not providing an opportunity for schools to not only guide the student in question, but also to ensure an environment conducive to learning is available for everyone, not just the students involved in the case, but every student. I ask that you please consider looking at making sure that we have the ability to have the information as parents of students who are also impacted. Thank you.
Thank you. Next, I see Mr. Willems.
Thank you, Madam Chair. John Willems, representing the Maryland Association of Boards of Education. You have MABE's written testimony in opposition to House Bill 146, a bill as introduced and as has been discussed, which would completely remove the mandatory requirement of notice to the school system by law enforcement agencies of arrests of students for alleged criminal behavior off school premises. I think that it's fair to say that on a bill this complex, you're bound to learn something during the bill hearing, and certainly from the proponents and from the sponsor, Delegate Moon. It's already been identified that this is a very complex issue. And if the desire is guardrails and accountability for the school system response to the notice, that is something very different, and I think something very worthwhile to pursue. But to completely eliminate the requirement that law enforcement notify the school administrator of even very serious crimes of violence and sexual crimes is what warrants our strong opposition to the bill as introduced. This is an area of law that has been the subject of some discussions around the edges about notification and exchange of information between agencies as well. And look, relating to the briefing we had earlier today, strong, clear rules for communication between school systems, the Department of Juvenile Services, and law enforcement could be very useful. And I don't think in any way that violates MABE's general position in opposition to these one-size-fits-all approaches. When it comes to interagency communication in the best interest of students, some clarification around communication and then what is done with that information is very, very appropriate. But this bill actually prevents communication and limits any mandatory communication to very after the fact, very late in the process. And that's of grave concern to us and the basis for our strong opposition to this bill. Thank you.
Thank you. And Ms. Danielle Susskind, please.
Yes, hi, good afternoon, Chair Atterbury and members of the Ways and Means Committee. I'm Danielle Susskind. I'm the Coordinator of Legislative Affairs for the Montgomery County Board of Education. I'm here today, like my colleagues, to oppose this bill. You heard from Dr. Mirsha, who is a principal at Paint Branch, and she is testifying not on behalf of the board, but on behalf of the Principals Association. However, we had a second principal who wanted to testify and had some trouble signing up. And so I'm actually going to read you his testimony because I think it's more powerful than what I could say from a board perspective. However, before I do that, I would like to make it clear that all 25 principals of high schools in Montgomery County oppose this bill. We have opposed this bill in 2020 as well. We had Dr. Eric Minus testify, principal of Sherwood High School, and today's testimony is from Dr. Dodd, who is the principal at Walt Whitman High School. And this testimony was written in conjunction with Ed Clark, who's the Chief Safety Officer for Montgomery County Public Schools and also the former head of the Maryland Center for School Safety. So this comes from our principals and from our safety officer and from our board. So again, speaking in the voice of Dr. Dodd, I strongly oppose House Bill 146 as it will create an unsafe learning environment for students and staff by not allowing local law enforcement to notify key school officials of when a student is arrested for a reportable offense that includes crimes of violence and other serious crimes in a timely manner. Montgomery County Public Schools has seen an unfortunate increase in students being arrested this school year for crimes of violence, to include murder, gun-related offenses, and other serious crimes. With the impact of the pandemics on students' well-being, providing a safe and secure environment in schools each day is our #1 priority. This would significantly limit school leaders' readiness to respond to the direct impacts that reportable offenses and arrests have on school safety. Along with the police, principals are often viewed as vital community leaders who are responsible for the safety of students, staff, and parents. Without this reportable offense information, local educators will not be able to collaborate with local law enforcement in ways that further protect the safety of students and community members. As both delegates Eversol and Buckell pointed out, this bill does change the words from shall to may, which would not require anyone to report this information. Under the current reportable offenses statute, local law enforcement.
I'm going to have to ask you to wrap up, please.
Yeah, sure. So we recently had a shooting in our school. We feel very strongly that things that happen outside of the community need to be put in. We have, as I said, a number of principals that would be willing to speak on this. We are asking you to find unfavorably on this and encourage the legislature to maintain the current statute on reportable offenses as it best serves the educational needs of students. Thank you.
I see Delegate Lukey, question.
Yeah, thank you, Madam Chair. Before my question, I just want to point out that Dr. Mirsha is the principal at Paint Branch High School in District 14, which clearly makes it a better high school than any high school in any of the rest of y'all's districts. So just want to say that for the record. Dr. Mirsha, can I ask you, because I'm a little unfamiliar with the exact process of how this occurs. When you get notification of a reportable offense, does it come directly to you or through the school system?
Usually comes through the school system, through our safety and security office. It is rare for them to communicate directly with principals. More often they communicate with safety and security in general, and then they communicate with us. But in the event of something in our community, if in any way it was, in the school or anything like that, then we would be communicated with directly. But something entirely outside of the school setting would go through the school system safety and security, and then they would communicate with us.
Okay, so the reporting in the bill then would theoretically come from that central office rather than burdening individual principals with additional reporting requirements, right?
Potentially. Superintendent's designee. The current law is the superintendent's designee, which in most places is considered the chief safety officer.
Okay, cool. Mr. Willems, thank you, Dr. Mirsha, I appreciate it. And keep doing a great job at Paint Branch. Mr. Willems, can I ask, so there's a provision, there's some provisions in the bill that I think are interesting and important, and I appreciate that you expressed a willingness to sort of get into the details and discuss some of them. But there's a section towards the end of the bill that gives students the right and their families the right to have a conference as a result, with the administration, as a result of a decision for a removal from school due to a reportable offense. I mean, that's the sort of thing that should be happening anyway in the special ed process, right? That if a student with an IEP is suspended, theoretically, there should be a meeting like that occurring.
Yes, and Delegate Lukey, you're probably not going to be surprised that I was very distressed to hear the use of the reportable offense statute characterized as an end around to the processes that would otherwise be required, particularly in the special education context, but really in other contexts relative to providing rights to students and parents and their due process rights specifically. So that is an issue on which we want to dig deeper and be responsive to. That's clearly it's news to me, and it's clearly not the intent of the reportable offense statute.
Okay, so then am I reading between the lines here? Does MABE have any objections to the increased reporting so we can determine what's actually happening with these reports and the disproportionality of it?
No,
okay.
and we've been pretty consistent in terms of, I believe it's Delegate Vice Chair Washington's bill in terms of data, around student discipline reporting, and we're no position on that bill. Which so we're definitely supportive of transparency and thoroughness in the data collection, and then with that information, hopefully inform better practices.
Okay, thank you very much, Mr. Williams. Thank you, Madam Chair.
Eversol.
Thanks, Madam Chair. Is my signal okay? I've been having a little trouble up here. I think I must have frozen up on you.
No, we can hear you fine.
Okay, great. So I'm starting to get a better sense of this after my first question is that this is designed for reportable offenses to give the school a sense of, I heard from some of the unfavorables, a sense of if the student is a danger to the community based on what they've done, if they feel they are. And I understand that concern. If that's true, who establishes the standard for that? What crimes and how they are? Is that completely up to the school administration once they get a reportable offense? Or is there some other standard that exists? And I'll take an answer from anybody who can help me with that.
Delegate Eversol, if I may, just in terms of an example of, I believe one of, if not the most recently added crimes, it's animal cruelty, and so these cases arise, and typically it's state's attorney's offices that will then promote and support additional crimes added to the list of reportable offenses, believing that it would have been appropriate had the school been notified of the arrest for that offense. And again, it's not just about safety and protection in that kind of criminal justice sense. It's also appropriate responses to the students from a behavioral health and psychological services perspective. And that's an important piece that look, we are likely to be falling short on based on staffing shortages and resources, but it is clearly the intent of the reportable offense statute that be a facet of the process and response.
But ultimately,
Eversol, if I can, there are enumerated crimes in the statute which are reportable. So they're specified in the statute. So one of the things that this legislation does is narrow that and makes it only crimes of violence.
Is there prescribed the schools have to, if they get a reportable offense report from a state's attorney, is it then up to their discretion at the school level what they do, or is there a prescription for what they have to do?
It's discretionary.
Thank you.
Mm-hmm. Delegate Barnes.
Thank you, Madam Chair. This is just a statement. I wanted to clarify for Delegate Lukey that Dr. Marishaw came from Prince George's County, the Largo High School in District 25. So she's on loan to you. Thank you.
Are there any other questions? Okay, seeing none. Delegate Feldmark, were you trying to ask a question or? No, I saw your hand. Okay, maybe not. Okay, with that, thank you everyone very much. That concludes the testimony on House Bill 146. Moving to House Bill 89, Delegate Queen. And I know you have a panel, but we will start with you.
All right. Good afternoon, Chair Atterbury, Vice Chair Washington, members of the Ways and Means Committee, and those from the Appropriation Committee who may be sitting on for this bill. For the record, I'm Delegate Pam Queen, and I'm presenting HB 89, which addresses an issue that has been exacerbated during the COVID-19 pandemic, which is the availability of childcare facilities. In Maryland, 79% of children under 12 years of age have a parent in the workforce. Due to COVID-19, with families keeping children at home, upwards of 51% of the childcare programs were in danger of closing. According to the Maryland Family Network survey, 67% of childcare business owners reported losses between $1,000 to $5,000 per week due to reduced attendance. HB 89 will provide needed support to childcare professionals to enable these business owners to remain open, reopen, or expand. This bill allows for 2 grants, one a childcare stabilization grant between the amounts of $1,000 to $35,000 to keep childcare facilities open, and a second child care expansion grant between $3,000 to $50,000 to enable child care facilities to expand. This bill will seek to get Maryland's working families back to work and stabilize the child care industry in Maryland. This bill is supported by the House Economic Stability Work Group, which seeks to address barriers to upward mobility of working families. You should have received a letter of support that was emailed to the committee about their support for this bill. And you will hear from childcare providers who need this continuous assistance so that they can stay open. So we seek a favorable recommendation for HB 89. Thank you.
Thank you, Delegate Queen. And yes, I should have mentioned that we do have members of the Appropriations Committee joining us, Delegate Solomon, Delegate Smith, back with your old colleagues here, Delegate Grice, and Council Michelle Lambert is here as well. So welcome, and I'll look for your hands to see if you have any questions. Next, Christina, I'm not going to say your last name, but good to see you. You're on mute. Still on mute.
Okay, can you hear me now?
Great.
Thank you. Great to see you as well, Delegate Atterbury. So thank you to the Chair Atterbury, Vice Chair Washington, and the esteemed Ways and Means Committee. I'm Christina Push, Executive Director of the Maryland State Child Care Association, a nonprofit representing more than 5,000 essential professionals in the child care early childhood workforce. A big thank you to Delegate Queen for her work on this legislation and for being a champion for children, families, and the child care community. MSCCA excitedly supports HB 89 to continue the necessary child care stabilization grants to support our struggling industry. In the best of times, Maryland's child care industry operates on razor-thin margins. Due to the COVID-19 pandemic, providers continue to face devastating losses and challenges. These are unique challenges the vulnerable child care industry faces as tuition-dependent small businesses, primarily women-owned and operated. Federal funds for stabilization and rescue efforts for the child care industry have been life-saving for many. However, more support is needed. HB 89 at the state level would be a continuation of the much-needed stabilization grants for the child care businesses. The COVID-19 pandemic has reinforced the essential role of child care and early learning for children, working families, and the economy. Critical workforce shortages, increased health risks, ever-changing regulations, guidance, and inflation have heightened concerns for child care providers, and many are at their breaking points. HB 89 grant programs provides financial assistance in critically important areas, including staff training, criminal background check fees, cleaning supplies, educational supplies, and important opportunities for capital and facilities improvement to increase more availability and access for families. I have an update from my written testimony, but from yesterday's state ECAC meeting, MSD reports as of December 21st, as of December 2020, over 900 licensed childcare programs have closed since the beginning of 2020, a decline of roughly 15%. We went from, in Maryland, 8,000 childcare businesses to 7,000 childcare businesses, and more continue to close fully or close classrooms due to critical workforce shortages, decreased enrollment, increased expenses, and continuous quarantine exclusions. Additionally, we have some programs with wait lists of families that cannot get in due to the lack of qualified, adequate staff, or program that may be full due to so many neighboring programs closing.
Ms. Push, I'm going to have to ask you to wrap up.
Yep. So these are red flags for our state leaders and policymakers, and that we will, if establishing these grant programs for the next 5 years, address some of these critical childcare issues. Thank you, and we urge a favorable report.
Thank you. Next, Ms. Ruby Daniels, please.
Thank you very much, Madam Chair, esteemed members of the Ways, Means, and Appropriations Committee. My name is Ruby Daniels. I'm the president of the Maryland State Family Child Care Association, representing nearly 4,500 family child care providers in Maryland. In the past years, more and more programs have been forced to close due to financial hardship, unprecedented under-enrollment, and other factors caused by the COVID-19 pandemic. In fact, since December 2019 and December 2021, 639 family child care programs across the state closed, leaving working families with fewer child care options and increasing the costs of those still able to find and afford quality care. This loss of child care programs was felt even more by families seeking infant and toddler spots, which were more scarce and costly before the pandemic, and made even more so afterwards with the shocks sustained by the early care and education workforce. House Bill 89 would provide financial assistance to childcare programs to stay in business and programs that need to expand, as well as helping new childcare programs with startup costs to meet the ever-growing demands of the working families. Historically, a large number of family childcare programs are started by young mothers. Some are immigrants and have no work experience in the US. Many has difficulties qualifying for loans because some banks require credit history, W-2, business checking account, and a sizable net income, which family childcare programs do not have. Without help, potential providers will not have the means to pay for criminal background check, physical, training, supplies, equipment, insurance, and minor renovation. Family childcare providers starting their business can expect to invest a minimum of $1,000 before opening their doors, but this amount could go as high as $10,000. House Bill 89 would offer the financial assistance for potential providers who wish to open their own business and existing family childcare programs who are struggling or who wish to hire additional adults or even expand their program.
Daniels, I'm going to have to ask you to wrap up your testimony, please.
Okay. I would like to respectfully ask for a favorable vote for House Bill 89, the Child Care Stabilization Grant and the Child Care Expansion Grant Program. Thank you for your time.
Thank you. Next, Joanne Hurt for 2 minutes, please.
Hi, my name is Joanne Hurt, and I'm the Executive Director of Wonders Early Learning and Extended Day, a nonprofit provider in Montgomery County. I'm here today as a member of Montgomery Moving Forward's Early Care and Education Workforce Advocacy Coalition. It's a coalition whose members represent a cross-sector of early education, business, labor, philanthropic, and nonprofit leaders from DC, Maryland, and Virginia. At the start of the COVID-19 pandemic, MMF convened this group who understood the urgent need that a diverse and resilient early care and education workforce is necessary for our state's economic recovery and critical to children's growth and development in their early years. We support HB 89, and we're grateful to Delegate Queen for her leadership and advocacy for the childcare sector. We also want to recognize and thank the entire Maryland General Assembly for your work on behalf of childcare providers throughout this pandemic. House Bill 89 establishes a state-funded childcare expansion grant program to assist with the financial barriers that existed prior to and have only grown since the pandemic. MSDE reports that 15% of licensed childcare programs have closed since March of 2020. Family and center-based childcare providers continue to closed due to decreased enrollment, increased expenses, and critical staffing shortages. The initial federal and state response to help stabilize our sector was really significant, but the childcare sector continues to struggle, as you've heard, as it navigates this ongoing crisis. Early care and education is an economic and social justice imperative and a pillar of Maryland's economy. We urge you to give HB 89 a favorable report.
Thank you. And last, Ms. Brianna January. That's a great name. That's like Marvel studio name. Like,
Thank you, Madam Chair. I surely will not be changing it anytime soon. Good afternoon, esteemed committee. For the record, my name is Brianna January with the Maryland Association of Counties, also known as MACO, and I'm pleased to testify today in support of HB 89. As always, you have my written testimony, so I'll be brief. HB 89 would support licensed childcare providers in our communities and would also incentivize the establishment of new providers at a time when the childcare community and county resources are pushed to their brink. As Delegate Queen and others have noted, the COVID-19 pandemic exacerbated Maryland's persistent childcare crisis. And while during the pandemic, counties have creatively addressed this issue by partnering with local nonprofits, departments of rec, for example, and by offering resources to the communities they serve. However, these county efforts cannot replace that which the state is able to provide to the childcare community. We all agree that reliable and safe childcare is critical for the success of Maryland's families and our communities. And so counties see the financial support offered by HB 89 as a welcomed resource to stabilize and strengthen the childcare community. And so for these reasons, MACO urges a favorable report from the committee. Thank you.
thank you. Are there any questions for the bill sponsor or any of the witnesses? Okay, seeing none, that concludes the testimony on House Bill 89. Thank you. And the last bill of the day, House Bill 226. Delegate Guyton, and I know you have a panel, so whenever you're ready, Delegate Guyton, you can begin.
Thank you so much, Madam Chair and colleagues on the Ways and Means Committee. For the record, I'm Delegate Michelle Guyton from District 42B in Baltimore County, and I am here to thank you for your consideration of House Bill 226. I woke up this morning knowing that this was a very good day. I feel blessed to be in front of you and offering all of us the opportunity to achieve what I believe is our most important charge as legislators, and that's to protect our most vulnerable students and our citizens. So those of us who are parents, we often take for granted daily check-ins with our kids. I know that I have 3 boys, and I can remember like very excited kindergarten conversations about new colors and learning about new countries and being able to spell a word. And then I also I'm very well aware that someday, especially in middle school and high school, I got grunts or rebuffs or mom, leave me alone. But whether they chose to tell me about their day or not at all, I knew that they could. Right? And I also knew that if I had concerns, I could get to the bottom of the situation and eventually get to the truth. But many of our constituents, most of the people you'll hear from today, they don't get to take those routine check-ins for granted. So their children get off the bus from school and they cannot talk to their parents about their day. They can't share the positives and the great things and tell them about their friends, and they can't answer parent concerns, even if the child is clearly upset. Even if that child is literally bruised and broken at the end of the day. And as you will hear, they have been, and they are. So House Bill 226 protects these students and their families by requiring cameras in self-contained special education classrooms where these children spend the majority of their day in our public school system. This committee has heard this bill before in other postures. This is the 3rd time I've come before you. And for whatever reason, this committee has chosen in the past not to move it. So I have worked with advocates, with teachers, with the state's attorney's office to refine the language of this bill, really anyone who would have a conversation with me about it over the interim. And I do believe very strongly that any issues that are raised in the couple of letters expressing concern that you have in the packet have been addressed in this year's legislation. So new language ensuring that concerns about access to video and confidentiality have been addressed. There's new language in the bill that guarantees that the video will not be monitored ever without cause and will not be used for teacher evaluation. So House Bill 226 has a dual purpose though. The bill does ensure the safety of vulnerable students, but it also protects teachers from allegations of abuse that can be difficult to prove or to disprove. This body has prioritized protection of vulnerable populations for many years with our investment and requirements regarding police body cameras. In just this past year, 2021 alone, we spent $32.4 million on this important initiative to protect the public. House Bill 226 is certainly consistent with these priorities and much less expensive. So in the last 3 years that the public, our constituents, have come to this committee, ripping the Band-Aids off of their pain over and over again, and begging us to act, to do something, to protect children who cannot speak for themselves. The following children have, and I must say, allegedly suffered in our school system. In Prince George's County, multiple kindergartens in an autism classroom who were nonverbal were hit and pushed by staff. A child came home missing teeth with a bloodied lip. A parent watching virtually while their child was home was able to report these incidents to the school system, and they're under investigation, but videos aren't admissible. So there really is no evidence that any of this occurred. A 5-year-old child in Anne Arundel County has regressed and cries every day. She keeps smacking herself on the bottom, something that her parents don't do, and comes home every day hoarse from crying or screaming. They're not sure. A 4-year-old in Baltimore County came home with burns up and down his back that have never been explained by the teachers. And over 7,000 cases of abuse of special education students in Frederick County alone have recently been exposed. It's hard for me to believe that if we had passed this bill 3 years ago, many of these injuries would not have happened, and these children and their families, your constituents, would not have suffered in this way. It's time for us to just stop making excuses and ask ourselves what we would do if they were our own children in this situation. I know how I will vote, and I implore you to do the same and to give a favorable report to House Bill 226. Thank you.
Thank you. Next, Lori Scott. Good to see you.
Good afternoon, Madam Chair, members of the committee. Thank you for having me again today for the third time. I'm in support of House Bill 226 to allow video surveillance in self-contained special education classrooms in Maryland. My daughter's a 19-year-old who has significant cognitive disabilities, in a wheelchair, and very limited verbal skills. She's unable to come home and talk to me about her day or to ward off any harm that may come her way. 3 years ago, in her self-contained public high school in Howard County, Maryland, where she attends, a paraprofessional grabbed the arms of a nonverbal autistic student, shook him, and released him into desks. It took 3 days for someone to come forward and report it to the principal, and 5 more days for the investigation to occur. Finally, the parents were then notified, the aide was suspended, and the child she abused was relocated to another school. After the aide's suspension, she returned to school due to representation from the union and got her job back. She returned to the classroom to be my daughter's aide. Needless to say, that wasn't going to work, and she was terminated. There have been multiple investigations and abuse incidents in Maryland over the years. Disability Right Maryland investigated Hickory Ridge Elementary School in 2014-15, where 10 students in one special education self-contained class were being abused. Teacher and aides were using spray bottles to spray water in kids' faces, banging rolling pins on desks to scare autistic kids, and chasing them with strong odored markers. This is abuse and would have been caught on cameras had they been available. You're going to hear heartbreaking stories today. We cannot allow this to continue. School should not hurt. There are 5 states who already have this law or a similar law in self-contained classrooms. Thank you, Mr. Dustin Renders from Disability Rights Texas, who stepped in the gap for the Texas students and for being here today. And the Disability Rights West Virginia, Mr. Cook, for providing us testimony. They're invaluable lessons that we need to learn from states around the country. We already have cameras in hallways and in vestibules all over the place in our schools, and we have large data servers, none of which you asked to pay for or you asked to allow them to be. We have cameras on our buses. Please, delegates, we need you to step into the gap right now to require school systems to install cameras in self-contained special education classrooms to stop abuse and harm for nonverbal, vulnerable students and to protect our teachers from exiting classrooms unnecessarily. Please support House Bill 226. Thank you.
Thank you. State's Attorney Rich Gibson from the magnificent Howard County. Hello, my friend.
How are you, Chair Atterbury? Good to see you. Good to see everyone. I have a lot of friends on the committee. It was good to see so many wonderful faces. So I'm State's Attorney for Howard County, but I'm also a career prosecutor with nearly 18 years of experience prosecuting cases in 3 jurisdictions within Maryland, those being Prince George's County, Baltimore City, and now Howard County. I'm here to urge a favorable report for this bill, and I hope that you all support it. The bill, if passed, will offer a level of protection to the weakest among us, special needs students who are non-communicative due to mental, physical, or emotional disabilities. It also protects those who work in schools from false allegations of preying on an extremely vulnerable class of people. 2 quick examples of incidents that happened in Howard County that weren't in the school setting, but were close enough related to it that directly would be impacted by this kind of bill are: 1, a few years ago, before I was elected into office in Howard County, there was a non-communicative child who, because of her disability, couldn't share what was going on with her orally. She was acting strangely. Her parents noticed odd behavior, and they complained. Luckily, the incidents of abuse were occurring on the bus, and there was a camera on the bus which captured the abuse, which allowed us to hold accountable the individuals abusing her and end the abuse, the cycle of abuse that was being brought upon that young child. Another example, in the other direction, I had a case that I reviewed here in Howard County where a daycare provider was accused of sexually assaulting the children in their care. There was video in the daycare center that captured the area where where the children and the daycare provider were interacting. And we watched 30 days of video and were able to determine that no abuse occurred, thus exonerating this daycare provider. I had an opportunity to review the written testimony submitted by the ACLU against the bill, in opposition to the bill, and I wanted to address that quickly if I could. They argue that there are students with disabilities that are overrepresented in disciplinary proceedings, and they believe that surveillance will increase the disproportionate treatment of those individuals. They further state that Black students receive a disproportionate amount of disciplinary actions, including arrest, and the presence of the video may negatively impact that. To those arguments, I would respond, what is offensive to our sensibilities is when similarly situated people in similar circumstances are treated differently based on color, gender, religion, national origin, or in this instance, disability. I hope no one is arguing that wrongful conduct should not be punished, but rather that similarly situated people should be extended the same benefits or receive the same sanction for their similar conduct. Just like body-worn camera for police, the video in this case acts to preserve the truth of interactions that occur in the classroom. So if the argument is that Black students or disabled students are being unfairly treated, why wouldn't we want video evidence to support that the presence of that, so we can do something to stop that unfair treatment? Same argument for anyone with disabilities or minority students.
I'm gonna have to ask you to wrap up.
Absolutely. Conversely, in that same environment, teachers and administrators in that space accused of behaving with bias would have a record to show they were actually behaving in an appropriate way. You can just go to the video. I ask that you support House Bill 226. Thank you.
Thank you. Next, Melissa Rosenberg.
Thank you, Madam Chair. I'm Melissa Rosenberg with the Howard County Autism Society, and I'm here today on behalf of the Autism Society and Pathfinders for Autism. We collectively submitted our testimony today to express our strong support for House Bill 226. and appreciate the opportunity to come before you. We're hoping that the third time will be the charm. We have supported this bill all 3 times and hope that you will give a favorable report. The number of stories continue to grow each year of camera footage capturing abuse of our children in schools. And yet for every one of these instances, there are many more reported or suspected cases of abuse that could be confirmed or refuted if there was a systematic way to capture video evidence in the matter. We're all acutely aware of the ruling by the Department of Justice right here in our own state, when staff from Frederick County Public Schools illegally restrained students with disabilities. Our non-speaking children with autism and other disabilities could never have shared this with their family and loved ones that they had been harmed, but a camera may have captured and possibly prevented these incidents. Children in special education classrooms are especially vulnerable to abuse because they often lack the ability to fully communicate any concerns adequately, creating the potential for egregious and continuing victimization. We also believe that this bill, as written, addresses any potential concerns about the use of cameras for monitoring teachers, and it sets forth clear guidelines for viewing the recordings. In our opinion, it's a balanced bill and provides much needed protections to our most vulnerable children and does not endanger the privacy of the children or staff. To that end, we recommend that the implementation of this important protection be done with sufficient planning to provide consistency across the state. It's imperative that the school systems, staff, and parents can be confident that this key initiative is installed with rigor and efficacy and with proper safeguards. Thank you in advance for your strong consideration in supporting this bill for the protection of our community. Thank you very much.
Thank you. Next, Ellen Calgary, please.
Good afternoon, Madam Chair, Mr. Vice Chair, committee members, and I want to thank especially the incredible work of Delegate Guyton in addressing these important and serious issues. The attorneys in my law firm represent children and adults with disabilities throughout Maryland. And for over 4 decades, I have worked to protect the most vulnerable members of our community, children and adults with disabilities. I began in 1979 as an assistant attorney general, and through today, I have a private law firm where we represent children and adults with disabilities. This is such an important issue. The parents of our clients watch in horror as their children come home off the bus with bruises, burns, broken bones, and no one can tell them how it happened. The greatest benefit of this bill, if it becomes law, is that these parents can have a proactive discussion with school staff members to say, how can we prevent this from ever happening again? And really analyze what steps need to be taken to protect their children. I similarly have had a case where my client was abused on a special needs bus, and we were able to find the perpetrators because there was video footage, and those individuals were actually fired. The damage had still been done, but the video footage helped us. So I urge this committee to give a favorable report for House Bill 226, and I thank you for listening to me today.
Thank you. Next, Tracy Monsieur for 2 minutes, please.
Hello. I'm the parent of a 6-year-old kindergartner in Hartford County Public Schools. My child has a robust IEP, and I'm very involved despite this. So I get upset. My little one was dragged through the halls of their elementary school in some non-sanctioned restraint procedure to a quiet room or a segregated classroom. This was done over 40 times by multiple staff, including admin and special educators. I have never given permission for restraint or seclusion use. When I asked if my small child was being restrained or secluded, I was told over and over again, no. They held ground that this was MSD's definition of an escort. I persisted to see footage, which was only available on hallway cameras. After the footage was viewed by Central, they acknowledged that this was not simply a transport or escort, as I was led to believe. No one believed me or my child. Without this footage, I had no proof of what my child had gone through. My 6-year-old has also spent significant time in a self-contained classroom at the school. My child was in this room with only staff and no peers for hours on end. I'll never know what happened in that room, as there were no cameras. My kindergartner was transported multiple times within that room to a corner made of gym mats. The window to the room was also covered with opaque paper after they began using the room for my child. My little one has been severely traumatized after only 4 months of kindergarten in our districted public Harford County Elementary School. And I'm left to pick up the pieces and try to make this right for my child. I ask you to support House Bill 226 as we clearly need cameras in the classrooms to protect the community's most vulnerable children.
Thank you, and thank you for sharing your story with us today. Next, we have Andy Culp for 2 minutes, please.
Hi, good afternoon, Chairman Atterbury, members of the committee. My name is Andy Culp, and I'm here to testify on behalf of the ARC Maryland in support of HB 226. And the ARC Maryland is the largest statewide advocacy organization dedicated to protecting and advancing the rights and quality of life of people with intellectual and developmental disabilities. And we've worked with the bill sponsor and other advocates over the past 2 years on this legislation to get it to its current state. It's very important to the ARC and our members that cameras be used appropriately and not be used to monitor teacher performance or student behavior, or to be used in placement decisions of students. And we're pleased that this bill contains protections against all of those uses. Our only goals are to provide information to administrators and law enforcement to do their best job in the investigation of alleged abuse or neglect, to deter abuse and neglect, and to provide parents with reliable information. We believe this bill this session has been perfected to achieve the greatest good and address the previous concerns and strengthen protections for students with disabilities and teachers in self-contained special education classrooms. And I've heard from parents as well whose children have come home from school with unexplained injuries or reports indicating that a student engaged in behavior resulting in self-inflicted injury, but sometimes the reports don't add up and parents are unable to obtain resolution. So they face uncertainty and fear for their child, fear of retaliation if they pursue the matter further. And access to video footage would enable a school to review an incident and to understand what may have occurred during an incident and then respond appropriately. In addition, we're currently experiencing a severe shortage of teachers, especially special education teachers. We can't afford the teachers to be removed from classrooms based on erroneous allegations, even for a short period of time. So we believe this legislation will accomplish 2 primary goals of giving a voice to the students who use non-traditional communication who otherwise face barriers to reliably recalling and relaying what may have happened to them, but also providing a tool for thorough and expeditious investigations that will help to remove teachers who are bad actors, but also expeditiously exonerate those who have been erroneously accused of wrongdoing and return them to the classroom. So in conclusion, I want to thank the sponsors for the work on this legislation and the committee for your consideration, and I respectfully ask for a favorable report on House Bill 226. Thank you.
Thank you. Next, Dustin Reidners is testifying for informational purposes only. Whenever you're ready. Is he on? Okay, maybe he had to hop off. I was calling him because he had to hop off, so we will move on. Next, Dustin Bain for 2 minutes, please.
Thank you, Madam Chair. My name is Dustin Bain. I'm the father of an 8-year-old autistic son. That's Ashton. And we hear these words, but I don't know that it's easily digested. I really want you to imagine you're going to school every day and you're being abused, mentally, physically, verbally abused. And you go home and you can't tell your parents. And they take you back to school for it to happen again the next day. And then you go home again and you can't tell a principal and you can't tell an aide and you can't tell help because you have no voice to protect yourself. And you start to wonder, why would my parent take me to keep getting abused every day? and they don't understand the type of trauma that you're going through, and it's happening all over this country. And it happened in our backyards in Frederick County at Caramana Elementary School, where an aide documented 2 years of abuse from a special needs teacher. During that investigation, my son came home with a bruise in the center of his back, bigger than the size of my fist, deep purple, not something that a kid doesn't cry about for 30 minutes. That would have been prevented. If we had cameras, they would have pulled the kids or pulled the parents from those classrooms. And if it wasn't one of the ones accused already that was in the investigation, they would have been worried about it being documented, and this would have been prevented. These cameras are in 5 other states already, and they're going to be across the country because it's common sense. We protect our vulnerable children. So we have 2 choices. We can lead by example and be one of the first movers on this and protect our children, or we can follow in shame after more children are being abused. Thank you.
Thank you. Next, Angela Sittler.
Hi. Yes, thank you, Madam Chair and other delegates. I'm here as a parent. I live in District 6 in Baltimore County. I am the parent of an 18-year-old child who's been in special education self-contained classrooms since he was 3 years old. And in Baltimore County, when you leave and these children with special needs go into the school system, they go in the day they turn 3. So he was a brand new baby 3. He's physically and cognitively impaired and cannot speak. So he can't tell me good or bad what happens in the school day. So I have to trust that these teachers, these aides, the staff are doing the best for him they can do. As you guys know, there's a huge staffing shortage. So even though I trust currently his staff and his teachers, they have constant influx of people, whether it be substitutes, whether the aides, the teacher, or whatever. And while they are supposed to be background checked, all a background check shows is that a person who has done this before has not been caught. I know this as a case, it wasn't in school, but we had an in-home caregiver who had a spotless background check, who worked in law enforcement, who was subsequently arrested on child pornography charges and had multiple years behind him of child porn. If this, and then my son was never able to get the prosecution of being molested by this gentleman because there was no cameras, and my son, because of the cognitive impairment, was not able to be interviewed because it wouldn't have been okay. So cameras in school could prevent anything like this happening from our kids before. They also, if the staff knows these cameras are in the building, they will not be doing these kind of things well because they know that they can be pulled. Also, it'll help protect the staff, as was mentioned before, from any kind of false allegations. My son falls a lot. He comes home with bruises. The staff would be happy to know that if he fell and was noticed by, say, a doctor or somebody else working with my child, they would immediately be noted that it was an accidental, and this teacher or staff would not be pulled out for unnecessary false allegations that can ruin their lives. So I implore you guys to please vote favorable for this bill to protect the most vulnerable of our students.
Thank you. Next, Ms. Martha Mock, please, for 2 minutes.
Thank you for hearing my testimony in support of House Bill 226. My name is Martha Mokad. While my children were enrolled at our local elementary school, I was a substitute in special ed classrooms for 2 years. I witnessed both verbal and physical abuse of special needs students by both teachers and instructional aides. The abuse of special education students by one teacher had been reported to school administrators by several aides over a 3-year period of time, and nothing happened. At the end of my 2nd year of substituting, we took this information to Frederick County Public Schools. We reached out to the superintendent, Board of Education members, Child Protective Services, the Sheriff Department, and Maryland Department of Education. The school district opened an investigation, but the superintendent made the final decision to keep the teacher in the classroom and move him to different schools. The district attorney made the decision to not charge him because the victims weren't able to speak about what happened to them. If there had been video footage, it could have spoken for these children. As I started advocating for this bill, I began researching and found in the last 11 years, there have been more than $46 million in settlements paid to families of abused special ed children as a result of litigation filed because of abuse by their teachers and aides.
Texas, West Virginia, and Louisiana have passed similar bills, and Georgia and Florida have passed laws to run pilot programs. Since passing these laws, abuse has been caught on video in their schools, and as a result, Texas and West Virginia are proposing amendments to their laws this year to strengthen them. Please support House Bill 226 to protect our most vulnerable students and give them a voice with cameras in their classrooms, as well as protecting their teachers from any false accusations. Thank you for your time and attention.
Thank you. Next, Ms. Susan Reinhardt for 2 minutes, please.
Hi. Thank you, Madam Chair, to the committee for taking the time to hear Destiny's story. It's only one of too many. This is Destiny. Destiny has cerebral palsy. Destiny fought to live before she was born. She had a stroke in utero as a result of drug exposure. Destiny was born addicted to opiates and spent her first months of her life alone in a hospital. Brian and I adopted Destiny from foster care in Calvert County. We moved to Anne Arundel County when my husband received military orders to the United States Naval Academy. I'm here today asking you to consider allowing cameras in self-contained classrooms. For the sake of time, I'll just talk about 2 incidents. Destiny was wheeled off the bus one day with a broken leg. Destiny's 100% nonverbal. She's dependent upon a wheelchair. She has quadrispastic cerebral palsy. She can't use her hands the way we can. She can't feed by mouth. She was wheeled off the bus one day with a broken leg. The school doesn't know what happened. Sorry, I was hearing the other parents. I thought I was hearing the other parents. It's so hard to hear other people go through it. You're going, this is Destiny. This broken leg resulted in surgery. Destiny had surgery, and to this day, we don't know what happened. I can tell you where the break of her leg did not happen. It didn't happen in the hallways because there were cameras and they were able to look at that. The break of her leg did not happen in the PE class because there was a camera. If only there was a camera in her classroom, we were told to move on. Second incident, a school employee was fired for physically mishandling Destiny. Employee was fired after another school employee viewed it and reported it. We were never told. Yes, you heard me correctly. My nonverbal child was physically assaulted by a school employee fired, and we were never told. How did I find out? I found out a week later when the fired employee called to tell me her side of the story. We called an IEP meeting with our attorney and AACPS, and we were told the fired employee had rights to her privacy. We still don't know what happened. At one point during the meeting, a school representative said they never imagined the fired employee would call me. Let that sink in. They never imagined we'd find out. Our attorney has a copy of the recording from this meeting, so does AACPS. This is fact. In sheer time, I know I'm running out. These are 3 more. I'm like shaking. This is Destiny wheeled off one day. If you see her nose, and then her eye. By the next day, it was all black. Again, she's nonverbal, and to remember, she's harnessed in a wheelchair, not for protection, for restraint, because she can't sit up. If she wasn't, she'd fall. So she's harnessed. Her feet are strapped again to help her. She can't move. She is just a target. So this bothers me because she's a target at school. And like everyone says, I believe a lot of it was kid on kid. This is burn marks on her neck. She had 3 incidents of this in 1 year. And as a child who's restrained in a wheelchair and the wheelchair locked down, she's a sitting, I had so many sleepless nights wondering, was someone strangling her? How do you get a burn mark like that? And this is why I'm here about the cameras as well. I want you to look at this, please. I know it's probably not great, but there's 40-something bruises on her legs. This was over weeks. Okay, when I say weeks, we kept calling the school. And actually, if you can see, there's a little pattern. It looked like an object with 2 things. Weeks. If there was a camera, because I'm pretty sure it was a student, if there was a camera after the second phone call that first week, they could have looked at the camera and seen that, yes, this was happening. Look at those legs. Again, she's strapped in there. Someone, like the shame she must have felt just being sit there and someone whacking her.
Miss Reinhardt, I'm gonna have to.
Okay. I will just say that Destiny now attends a non-public school, and I'm here to still speak up on behalf of all the Destinies. No one should have to go through that. And since starting at her school over a year ago, she hasn't had one injury. They have cameras. Thank you.
Thank you. Next, Miss Andrea Smedley Hasty, please, for 2 minutes.
Hello, thank you, everyone. Good evening. I'm in support of House Bill 226. I'm retired Prince George's County Public Safety, and not only have I ran calls for these types of abuse, but my grandson is autistic and was abused in Prince George's County Public School and at the Children's Guild at age 4 and age 6. If there were cameras, though Josiah is verbal, he cannot articulate his events of the day. If there had been cameras with Josiah's abuses, our answers to all of our questions would have been answered. To date, we have no answers to any of these questions. Josiah is 8. He has been to 5 schools, and I'm going to show a few pictures. He would cry every day when he had to go to school, and then these are his injuries that he sustained while being in the school. Bruises, this is him, how he would sit. If I would pop up in the school, this is how I would see him sitting, like he was just so frustrated and could not let us know what was going on. Just bruises and mark after mark, marks on his face, scratches where the hospital said it looked like he had been clawed. It was just, it's been a very, very long and trying process. More scratches on his face, no answers to any of our questions at all. It has been traumatic. We have spent thousands of dollars in legal fees and for him to have a PTSD therapist. And I truly believe that if we had cameras in the classrooms, a lot of this would be alleviated and parents wouldn't have to feel like myself and the other ones, like Mr. Bain. I feel the same way. Like I was just sending him to the wolves every day and he's looking at me for protection, but I'm sending him to these people that are harming him. So I'm in favor of House Bill 226, and I hope everyone gets on board and protects our children. Thank you so much.
Thank you. Next, Miss Jacqueline Pennington, please, for 2 minutes. Which I don't see her in here. Jacqueline Pennington. Okay, and last, Craig Bowden. Are you in the room? Craig Bowden?
I don't think he's here, Madam Chair.
Okay, thank you, Haley. Delegate Guyton, did you want to read the testimony of the gentleman that had to leave?
Thank you, Madam Chair. I appreciate your willingness to let me do that. He was testifying from Disability Rights Texas. He works in the school system and they are experiencing a terrible storm and they had to close early. So he was driving away as you were calling him, but I thank you for the flexibility. So we had him come and speak today because over the past couple of years, we've been asked about implementation in other states. How is this working? What are the issues? Are the concerns that have been raised in the past that seem to be dwindling, but have they come to fruition or have things been better or worse than expected? So I'm just gonna read a few pieces of his letter. You do have it. You also have about 150 other letters from parents all over the state in the packet. So I hope that you'll take a look at those. This says, I'm providing the following information about the experience of Texas in providing cameras in special education classrooms. I serve as a supervising attorney of the education team at Disability Rights Texas and the protection advocacy agents in Texas. Texas Disability Rights was initially neutral on the Texas legislation providing for cameras in special education classrooms, but quickly found cameras to be invaluable tools in making classrooms safe for vulnerable students. We recognize that cameras were already common in public school common areas institutional settings serving people with disability, and in law enforcement. We had concerns about potential impacts on student discipline, competing interests around privacy and parent access, and what we might learn practically from the camera footage. Reviewing camera footage has become a routine part of our work to investigate unknown injuries, but also to determine the appropriateness of restraint and crisis intervention when students are injured. There have been countless times when camera footage vindicated an educator or student or created a learning opportunity on how to better handle crisis intervention in the future. Camera footage has been most helpful in determining what occurred during restraints that resulted in injury or other crisis situations, resulting in injury. Cameras can also provide some parents more peace of mind in sending a child back to school after an injury. I would point out that the cameras have been useful in special education behavioral classrooms where restraint is common, regardless of whether students use words to communicate. So we have not seen any of the potential downsides of cameras that we feared. We've not seen cameras in special education classrooms result in greater exclusionary discipline. In fact, we've seen the opposite occurred where expulsion was recommended before footage requested by the parent, but then the footage vindicated our client and the district withdrew the requested expulsion. Our district attorneys decided not to prosecute the student. We have also been able to file grievances on school police officers for misconduct caught on camera when officers were responding in a classroom crisis. So the existence of videos have greatly expanded what we can do with our P&A investigations in public schools, which we have used to conduct systemic investigations of programs of concern. He goes on to talk about how they use some of this footage to actually come up with training programs and to document injuries in certain places. So it's a long letter. So I will also say in several cases, those involved in these investigations, abuse was uncovered on the video, resulting in findings of child abuse prosecution and loss of educator certifications. The benefits of cameras in the classroom have been undisputable. Yeah. Mm-hmm.
I'm gonna have to ask
you. You may cut me off.
I'm cutting him off, not you. But if you want to, I don't know if we already have that submitted as written, but certainly be submitted.
Certainly. Yeah. And then I appreciate it. I appreciate your tolerance on that. We were almost to the bottom. Basically, they say they were very concerned and now they love it and they want to expand it. So that's the message from Texas. And you also have a letter from West Virginia who also has this program in great support.
Thank you. So that concludes the testimony. I do see two questions, Delegate Palakovich-Carr and then Delegate Griffith.
Thank you, Madam Chair. A question actually for Delegate Guyton. My recollection is that when we've heard this bill in past years that MSEA, I think, was opposed to the legislation, and I might have missed it when you were giving your testimony earlier on. Do they have a position on the bill this year?
They do not have a position on the bill at all this year. They have worked with us very carefully to make sure that they were comfortable with the language.
Thank you.
Delegate Griffith.
Thank you, Madam Chair. And you know, those of you who know me, this is very important to me as a father of a 7-year-old who's a nonverbal autistic child at Hickory Elementary in Harford County. You know, first, all the parents that gave testimony today, thank you for your courage and your bravery. This is not an easy thing to talk about, the thing that scares us all the most, our nonverbal child being abused, and worse yet, not being able to express themselves to us. It keeps all of us up every night. And to Tracy, obviously, we've been in contact with you and we're gonna make sure we do everything we can to help you find justice in your matter as well. So thank you, Delegate Guyton and Delegate Lukey for bringing this forward. And I'm gonna do everything I can to push this forward. Thank you for testifying today, I appreciate it.
Are there any questions? Okay, seeing none, that concludes the testimony on House Bill 226. Thank you all very much. Committee, we will meet again on Tuesday, the 8th at 1 p.m. to continue bill hearings. Do any subcommittee chairs want to announce any subcommittee meetings?
Yes, Madam Chair.
Go ahead.
The Election Law Subcommittee will meet this upcoming Tuesday at 11 a.m. for our first meeting. Tuesday at 11 a.m. Please see your emails for the bills that we will be discussing and voting on.
Thank you. Anyone else?
Local revenues, we will meet on Wednesday, right after bill hearing.
Madam Chair, revenues will meet at noon on Tuesday.
Okay. Is that it? Okay, thank you, everyone. See you.
Thank you.